Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Hello, everybody. Here's part 2. Oh my gosh, they nailed me. You want to see what they nailed me for? I am appalled and shocked. Take a look at your content. Nudity, unclothed and actual content. What the hell? There was nothing inappropriate. This is court. Oh. So I took action. I'm appealing this decision. I was like, what the hell? What was said? What was done? Does anybody have an idea? This is new to me. Totally new to me. I have never. Did anybody say something wrong in chat? We have a coverall. Oh, did that do it? We have bingo. All things are marked. I don't know. I have no idea what they're referring to. I'm confused. What about you guys? But I don't think that would have dinged it. What do you think? I'm trying to get everything up and running for you guys again. The bingo, I'll put that up so we can make sure we have everybody gets into that. But I have no idea why I got dinged for that. Are y'all seeing me? Somebody go over in live communication and talk to me. Maud, I need you in live. I see we have a bunch of comments. My numbers are going back up, but they're not. Oh, wow. That's an odd change in numbers. Everyone's saying bingo, 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 like. No, somehow they think I did something that has to do with, we don't even put that N word in right now. I'm just gonna delete the comment, Haley Mouse. Just don't even say it. No, YouTube said that there was inappropriate, content such as unclothed or, intimate behavior. I don't I that's how I feel right now. I Oh, snap, it just deleted it. Did it really? I gotta do that all over again. This sucks, y'all. Big time. I gotta set up all the I liked, I subs, and all of that. I mean, I'm setting it up. But it is appalling because I didn't do anything wrong. And it stays up in my record for people to see for 90 days. And and I have to take a test and do all this crazy crap to get rid of it. I'm like, seriously, y'all? Seriously. I don't understand. It's frustrating. Very frustrating. Okay, I got that over there. Facebook there. I'm trying to get everything relayed out because I have to get us back to where we were on the trial, and I got to figure that out. So give me a minute. I got to get the video up and running. I really don't understand. I think they got it set too sensitive, too sensitive. I'm trying to get us up. Hey, I got it.
Have you ever seen collisions where more than one person was hit
Okay,
or
there we
struck
go.
by the vehicle?
Multiple pedestrians, you mean?
Yes.
We have blacked out our bingo card. So everybody, if you say I bingo, will get extra entries. We have a full blackout.
Yes, sir.
And have you ever
Thank
seen
you.
in a collision where the vehicle's going the same speed when it hits multiple different people, there can be multiple different injuries?
That is so vague, and you'd have to go back and look at a specific case, look at the injuries, look at the vehicle, look at the people. You can't just say, is it possible this could occur? You have to
Amen.
look at a specific case and demonstrate that that could actually happen.
Well, I'm not asking if it's possible. I'm asking in your experience. Have you?
Well,
I'm going to allow
I could have been. I don't know, but I've appealed it.
ever been involved in evaluating multiple pedestrian crash where there are multiple pedestrians hit by one vehicle and they sustain different, or in some cases no?
Just
Has
once.
that ever happened
Just
to
do
you?
it again.
Sure, because
sure
it
I get
depends
it.
where they're hit, what part of the body they're hit on, what the force is for that hit. The people aren't going to be hit the same multiply by one vehicle. You can certainly have multiple people and different types of injuries.
Have you seen people hit by a vehicle at a particular speed and have certain injuries, and then you've seen other cases where people are hit by a vehicle similar speed but have no injuries? Have you ever seen that?
I'm going to allow it.
So what do you mean by injuries?
Have you ever seen, in any of your cases, a pedestrian hit at a certain speed and have injuries, and another case where you look at where there is a similar type collision with different injuries?
So again, do you mean abrasions, cut, laceration, fracture? Do you mean same cars? It's not something that you look for and compare between cases. You'd have to go back and actually study the cases and look at the details.
Having experience in pedestrian collisions, you can't think of a similarity between cases as far as vehicles and speeds and totally different injuries occurring?
I'm going to allow that. Can you?
Do you mean hit the same way with the same type of car at the same speed with the same force?
I'm going to allow it. Can you answer it?
I don't believe I've ever seen a case where two people were hit with the same car at the same speed with the same force with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1, have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
It certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Yeah. Well, sure. I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll
sir.
get to the contact. When you looked at all the tests you did, the plastic broke differently in each and every case, every experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
Well, I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No more comments.
When
Yay,
you
she
did your
finally
experiments,
disciplined him.
the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not, no, sir.
Okay. You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only test he performed, and he referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Oh, Your Honor!
So, Mr. Jackson,
Objection!
Mr. Brent, I'm going to seek counsel at sidebar.
Yeah, I did. Yeah, I did. That just made me mad. Really? There is no need for his behavior right now. I don't care which attorney is doing it. I don't care. I want to see if they show me where.
You guys for the jury. Front door, right here.
I don't know where. I'm looking to see. All right, they are on their lunch break. Oh my gosh, y'all. I'm at 2,925 subscribers. Please. Come on, y'all. Come on, y'all. Help me get to 3,000. That would be fabulous. Okay. So now what we're going to do, we're going to go over to yesterday's Lori Daybell's trial. And we are going to start watching her during the lunch break. We are going to be zooming it because we can. Let me get it up. I had to close everything down because of day 2, day 4. Okay, she is still. Let me share this. Get it big. I'm trying to do a lot at once. I'm dealing with this. Hey, Jen, welcome aboard. For those of you who don't know, we just got a strike for unclothing and intimate, inappropriate acts that we never showed. I don't know how that happened, but we didn't show it. But y'all help me get to 3,000. Please subscribe. It doesn't cost you anything. And I have a ton of you over on X. Hop on over, hit the subscribe, and then leave. That would be fine.
DNA profiles
Here
and
we go.
reach any conclusions?
Yes.
In this case, were you provided with several cuttings from Lisa Perry from swabs from a vehicle?
Yes, I was.
And were you provided with a DNA profile for an Alexander Cox that was developed by Emilyn Sapinoso?
After I completed the analysis of my samples, I compared the results from my samples to any known individuals that were also submitted for the same case.
And was that for the Alexander Cox?
Correct.
Were you then asked to develop DNA profiles from those cuttings that Lisa Perry had given to you?
Yes,
And then compare those to Alexander Cox?
correct.
Were you provided a cutting of a swab from the steering wheel of the Jeep?
Yes.
Were you able to create a DNA profile from that?
May I refer to my report?
If that would help refresh your recollection.
Go ahead.
Yeah, do you have that with you?
I do, I can.
Or do you need a copy?
Is it okay if I was writing?
Yeah, go ahead.
Yes, I was able to generate a DNA profile for the sample.
From the steering wheel.
Yes,
Were you able to determine how many contributors were in, well, let me ask you, was that a mixture?
it was a mixture. I have a major conclusive profile and the minor portion is inconclusive.
Okay. And for the minor, were you able to determine how many, I guess, contributors were in that mixture?
I have a minimum of 3 contributors.
Okay. Were you able to tell anything about the sex of the major contributor?
The major contributor is of male origin.
And were you able to tell anything about the sex of the minor contributors?
Since it's inconclusive, I didn't make any comparisons or I didn't make any conclusions for the minor component.
Did you compare that major contributor DNA profile from the swab of the steering wheel to the known DNA profile of Alex Cox?
Yes, the major profile obtained from this item matches the DNA profile from Alexander Cox.
Do you have any statistics as to the frequency of that occurrence?
Yes.
Could you tell us those?
May I read from the report?
Go ahead.
The frequency of occurrence of an unrelated individual in a random population having the same genetic profile as the major DNA profile obtained from this item is approximately 1 in 975 sextillion African Americans, 1 in 111 quintillion Caucasians, and 1 in 344 quintillion Southwestern Hispanics.
What is a quintillion?
A quintillion is a 1 followed by 18 zeros.
Were you provided with additional other swab cuttings to also attempt to develop DNA profiles?
Yes.
Were you provided with a cutting from the passenger seat belt buckle?
Yes.
Were you able to develop a DNA profile from that?
No, this profile was inconclusive due to an insufficient amount of DNA.
What does that mean?
It means that I didn't have enough information to conclusively give any results that are reliable.
So it doesn't mean
We are using yesterday's bingo card. Yesterday's for this one.
there's no DNA there.
Correct.
Just means you didn't get enough DNA to do any type of comparison.
Yes.
Okay. Were you provided with a cutting from Lisa Perry from the swab from the passenger interior door handle?
Yes.
Were you able to develop a DNA profile for that?
No, this was also an inconclusive DNA result.
What?
Was there again insufficient DNA?
Yes.
Were you provided with swabs from the lug nuts from the spare tire of that Jeep vehicle?
Wrong chat.
Yes.
Were you able to develop a DNA profile from that?
No, this DNA profile was inconclusive due to an insufficient amount of DNA.
So again, there's DNA there, correct?
Correct.
But just not enough of it for you to do any comparisons.
Yes.
Were you provided with a cutting of the swab from the gear shift of that Jeep?
Yes.
And were you able to develop a DNA profile from that?
Yes, this is a DNA mixture that indicates that there's at least 3 individuals of male and female origin.
Did you have a major contributor to that DNA profile?
I did not.
Were you able to make any determinations as to sex of any of those contributors?
Yes, I made a determination that Alexander Cox cannot be eliminated as a contributor to the DNA mixture.
What does that mean?
That means that when looking at the DNA profile that I generated from the gear shifter, the different numbers that I have on my DNA profile for the gear shifter, the numbers that Alexander Cox has on his DNA profile, he cannot be eliminated from my conclusive locations. So for example, if he has, let's say, a 7 and an 8 at one location, the DNA profile that I generated from the gear shifter also has those same numbers. So there's not a difference in the profile from the gear shifter and the profile from Alexander Cox.
Now, so for the gear shift, you can't eliminate him because there's no inconsistencies in those profiles. There's just not enough information for you to make that conclusion?
Yes, there's no inconsistencies between the two.
Thank you. Were you provided with cuttings from the swab from Lisa Perry from the driver's side seatbelt buckle?
Yes.
Were you able to develop a DNA profile from that?
Yes, the major DNA profile from this item matches the DNA profile.
Okay, here's the bingo card that this should bring us up to date from yesterday to today. So this is what's left on the bingo card. I'll leave it up for a minute for people to get their bearings. This is what we started last night. We unfortunately, due to extreme weather, I had to end the live. So I'll give you a second. Okay, there you go. To get caught up. Screenshot it. That's the best way to do it. Okay, here we go.
It is a mixture. The minor is inconclusive and the major is conclusive.
So the major was the DNA profile that you compared then to Alex Cox?
The major profile that I obtained matches Alexander Cox, correct?
And did you have statistics for the frequency of occurrence for this match from the driver's side seat belt buckle when you compared that DNA profile to Alexander Cox?
Yes. The frequency of occurrence of an unrelated individual in a random population having the same genetic profile as the major DNA profile obtained from this item is approximately 1 in 123 nonillion African Americans, 1 in 715 septillion Caucasians, and 1 in 2.78 octillion Southwestern Hispanics.
Septillion. I think that's a different number. What is that?
Septillion is a 1 followed by 24 zeros.
So a higher frequency even than the other match.
Yes.
So in this case, 2 of the swabs that you tested, both the steering wheel itself and the driver's side seat belt buckle, had major contributors where the DNA profile from those 2 items matched the DNA profile of Alexander Cox.
Yes.
Did that conclude your involvement in comparing these swabs to the known sample of Alexander Cox?
It did.
Thank you. The state has no other questions.
Cross?
No questions, Your Honor.
Any questions for this witness from any member?
Oh my
of the
God,
board?
did you hear that?
I don't see any.
No
All right,
questions, Your
thank you. You can
Honor.
step down.
Thank you.
Thank you,
All right,
June.
let's recess for lunch. Can we resume at 1:15, everyone? Okay. Next witness.
State Counsel Kyle Mueller.
All right, sir, come on up. Stand in front of my clerk here and be sworn in.
I am appalled.
All right, you're gonna have
I'm
go up this
appalled.
ramp. Have a seat to my left.
I got hit by YouTube police for something we didn't do.
Would you please introduce yourself to the jury?
Sure. My name is Kyle Mueller. I'm a forensic scientist section supervisor with the City of Phoenix Police Department Crime Lab
How long have you worked for the City of Phoenix Crime Lab?
for about 24 years now.
And can you tell us the different duties you have done over those 24 years?
Sure. I started out in the controlled substances section where I analyzed illicit drugs for the presence or absence of an illicit drug. I then transferred to the trace evidence section in 2007 and was a forensic scientist 2, and then a forensic scientist 3, and then 4, and then now I'm the supervisor. In the trace evidence section, I analyze gunshot residue kits, footwear and tire track impression evidence, fibers, tape, and miscellaneous unknowns.
Can you tell us the education and training you've had in the area of trace evidence specific to GSR, gunshot residue?
Sure. Well, to start, I have a bachelor's of science in biochemistry. That's from the University of Arizona. I also have a master's of science in forensic science from the University of Florida. I've been trained by senior members of the crime lab, but I've also received several training opportunities for trace evidence, whether it's internal or external where possible. Specifically towards gunshot residue, there's a lot of history in the scientific literature for reading about what GSR is and how it's created. It's also a matter of going through the specific training program with the Phoenix PD Crime Lab. So I went through that, and I'm also proficiency tested on a yearly basis.
Can you tell us how long was that training at the City of Phoenix to work in the trace area?
Well, the training is ongoing, but so each subdiscipline in trace evidence, you need to go through the training program and then become competent in that subdiscipline. So, and for specifically, excuse me, for gunshot residue, it was about 6 to 8 months.
And then you said you have ongoing proficiency training. Can you tell us what you mean by that?
Sure. Every year, I receive a proficiency test to verify that I'm valid or competent in analyzing gunshot residue.
Well, let's start with then, what is gunshot residue?
Sure. Gunshot residue, or GSR for short, are small metallic particles that are formed from the discharge of a firearm. So when someone shoots a gun, these small particles are made up of the elements of lead, antimony, and barium that are from the primer paste inside the bottom of a cartridge casing. That primer paste essentially is disintegrated, and we're left with these GSR particles that escape from any part of the firearm that's not completely closed in the manufacturing process. There are effectively 3 classifications that we test for gunshot residue. There's characteristic particles that have all 3 elements of lead, antimony, and barium. There's also consistent particles that have 2 of the 3 of those, so lead and barium, or lead and antimony, or antimony and barium. There's also commonly associated particles, and those are just lead particles. So that plume of smoke that you see when you shoot a gun, a lot of that plume, if you will, are these small metallic particles.
When that plume lands on things, is it visible? Can I look over here and say, hey, there's a GSR particle?
No, these are very small. They're anywhere from 5, 10, maybe 5 or 15 microns in width. To give you an example, if you were to take a cross-section of a human hair, that's around 60 to 90 microns. So these are very small particles. You can't see them with the naked eye. We have a very high-powered microscope in the SEM, or excuse me, in the trace evidence section called an SEM, and that's what we use for our analysis.
So does it matter if someone fires a handgun or a rifle? Is it going to be the same particles you're looking for?
Those same particles are generated regardless of the caliber of firearm used or the ammunition used. We still look for those 3 elements within that same type of particle.
When someone discharges a gun, what factors might impact whether or not that GSR residue particles are left on a person or objects around the gun?
Well, you can imagine that when someone shoots a gun, it's kind of like that plume of smoke that's generated. It's kind of like smoking a cigarette. That plume of smoke is going to travel one way or the other based on if you're outside, if you're inside, if you're and it's a windy day or if it's raining. So if you're in an enclosed place, depending on where the wind velocity is, it's going to depend on where that travels.
So if a person fires a gun from inside a vehicle while it's parked, would you in general expect to find GSR particles inside that vehicle?
Yes, it's certainly possible.
Okay. Can GSR particles over time get lost or removed from whatever object they have attached to after the gun is discharged?
So these particles, like I said before, they're like a fine metallic dust. They don't have a half-life. They don't decay over time. They don't evaporate. They're simply just washed away. So if GSR particles are found on an object, they will stay there indefinitely until they're washed away.
Okay. Have you seen cases where GSR was found inside a vehicle weeks or months after someone has fired a gun inside that car?
It's possible, yes.
In a case where it's alleged that a person was inside a rear portion of a Jeep and fired a rifle out the back window, would it be within the normal scope of possibilities to locate GSR on the windows of that vehicle a month after the shooting?
It's possible, yes.
Would it be impacted if, say, someone went in the Jeep and sprayed some Windex and cleaned off all the windows? Would that then remove it?
Yes, it would possibly remove any GSR.
So when we're talking about collection of an item that's not immediately after the discharge, does the fact of someone cleaning or not cleaning the area around the discharge impact the potential to collect those particles?
Yes, it would potentially remove those particles.
Can you tell us, in general, what you are provided with and then how you look for GSR particles with the kit you are given?
Sure. Depending on the case, a general GSR kit has vials inside of that kit. They're labeled usually about where they are collected from. There's essentially a plastic vial, and when you open up, when you open up the cap to that plastic vial, on the inside of that cap is a small aluminum stub that has effectively sticky tape on it, and that tape is used to sample an area. The The portion being, or the idea behind that is that if you have GSR on an area, whether it's someone's hands or an inanimate object, you would then stub that sample, and then any GSR on that sample will then be transferred to that stub. Now, those GSR stubs are then introduced as evidence into the laboratory, and that's where I come in and I test that evidence. So the GSR vials and those stubs are essentially, they come in a GSR kit that's labeled depending on the evidence, and then start my note-taking process regarding what the GSR labels say, where they're taken from, and then I essentially take those stubs out of those vials and place them in an instrument called an SEM EDS. And that essentially stands for Scanning Electron Microscopy with Energy Dispersive X-ray Spectroscopy. And so essentially what I'm doing is I'm introducing those stubs into that SEM because it's a very high power microscope to view these very small particles. I then analyze the kit with a program that we have for looking for GSR particles. The program then generates a report of what it found, and then I go back typically the next day and try to determine if these were actual GSR particles that were detected by the instrument or whether they were not. And then I compile my report with my results.
You told us earlier that there are 3 different elements you are looking for. What is the significance of locating 1, 2 of them together, or all 3 of those elements together in one particle?
So one particle that has all 3 elements is called characteristic, meaning that that is unlikely to have come from any other source in the environment other than from the discharge of a firearm. 2 of those, so a consistent particle is 2 of those elements, so lead and antimony, or lead and barium, or antimony and barium. And those are consistent particles, meaning that while they're also associated with the discharge of a firearm, they're also found in the environment. Lead is a commonly associated with particle, and while it's found in the environment, it's also found in, again, GSR, this plume of smoke that we see when someone discharges a weapon.
So you told us you work for the Phoenix Police Department. Do you still, does your agency assist other agencies with processing GSR kits?
Yes, we do.
On January of 2020, were you provided with 2 GSR collection kits from the Gilbert Police Department?
Yes, I was.
And were those marked with the Gilbert property identification numbers of 645-886 and 645-888?
Yes,
Were you asked to analyze these?
I was.
When you receive those, do you note whether or not they are integrity seals have been kept there and that they are still properly sealed when they arrive to you?
Yes, I do.
And were they still properly sealed with all integrity seals on them?
Yes, they were.
Now, the kits or the vials, do those come inside their own container, and then each vial itself is also individually sealed with the tag, I guess?
So the vials themselves that have the GSR stubs in them aren't individually sealed. They're usually anyway 3 to 4 of a pack, if you will, of vials. And then inside of that, those vials are then inside another envelope, which is inside the GSR kit.
Do the vials, though, have their own, I guess you indicated label, tape, whatever we want to say, going around them indicating what each one is from?
Yes.
Okay. So in this case, when you received those 2 kits, each of the vials had their own tape with the labeling and then were packaged in sealed packaging.
Yes, that's correct.
And when you were provided with these 2 items, these 2 kits, did you, can you tell us what your initial process was?
Sure. I received notification from the Gilbert Police Department of where exactly these GSR vials were collected, so I could get a better idea of what to test first. So I got that information, and then I started my analysis on one of the GSR kits from 3 of the vials were from the inside of the Jeep, specifically the windows.
Why did you want to test the windows of the Jeep versus the tabs that may have been from, say, the back of the seats of the Jeep?
Well, testing the windows first I thought was pertinent because they're more likely to not come into contact with an item that would previously had GSR on it. If GSR is on the inside of a window, unless it's been cleaned, it would probably be there still.
Okay. The GSR kit that you decided to test, did that contain stubs from the passenger side interior back window, the passenger side interior window, and the driver's side interior window?
Yes.
I assume you used the same process with the SEM microscope that you described?
Yes, that's correct.
And then you independently confirm whether or not what the microscope located is in fact the items it indicates?
Correct.
For this one, starting with the passenger side interior back window, did you find any particles in that collection kit commonly associated with GSR?
Yes.
And so again, so we understand for commonly associated, what does that mean?
That means those are lead particles.
Okay, so just the single individual lead particles, and you found those on that stub.
Correct.
So for that same passenger side interior back window, did you find any particles consistent with GSR?
Yes, I did.
And again, just so we understand, what does consistent with GSR mean?
That means 2 of the 3 elements from a characteristic particle are present.
And do you in fact even note how many of those particles you find?
Yes, I do.
When you are looking for those, do you count every single one on the entire stub? Or do you at some point say that's enough to show they're there?
After 10, essentially, I stop. So if it's anything less than 10, I count and put that in my notes.
All right. When you were looking at this passenger side interior back window, did you find any particles that were characteristic of GSR?
Yes, I did.
And again, what does characteristic mean?
That means it has one particle that has the elements of lead, antimony, and barium. That is kind of a round or amorphous morphology that is characteristic of being from the discharge of a firearm.
Okay. So when you located the commonly associated, consistent with, and characteristic particles, what was your conclusion as to the kit that was used to collect from the passenger side interior back window?
Again, that area of the Jeep is consistent with being in the vicinity of a discharged firearm or even coming into contact with something that had GSR on it.
Okay. Was one of the other vials that we discussed from the passenger interior window?
Yes.
Did you find any particles commonly associated with GSR on that stub?
Yes, I did.
How about consistent with or characteristic of?
No, I did not.
So what was your conclusion as to that vial where you just had particles commonly associated with GSR?
So to back up, when I put together my report, I took the results from all 3 samples that I tested and made my conclusion on that. If I'm looking at individual vials, so the vial that we just spoke about that had just the commonly associated with, that means that, again, a discharged weapon could have occurred within the vicinity of that sample being taken, but it could also come from an environmental source as well. But that's just for that one sample.
In a vehicle where a gun is discharged and the samples aren't collected till about a month later, why is it important to look at multiple locations?
Well, so when a gun is discharged and you think of that plume of smoke, those GSR particles are going to travel anywhere potentially in the inside of that vehicle. So any of those areas could potentially have GSR on them. So when I performed my analysis on those samples.
Sorry, guys, I had someone come in, the gentleman that's been using my studio the last 2 nights. So all is good, all is well. Look, I've got to take another comfort break. I've got to step away for a minute. This is lunch. So I'm going to leave this running. I'll be right back. And then we've got a document from Miss Lori Daybell. I will go ahead and do the document for Miss Lori Daybell. This is a minute entry from Lori Ann Daybell. This court has received defendant's motion to dismiss abuse of discretion and motion for recusal of Chief Judge Green. The ruling is only addressed these 2 motions insofar as they seek to change the judge or cause pursuant to Arizona rule, blah, 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 that extends the motion to seek other relief to assign the assigned trial judge will handle the request. Rule 10.1 covers the change of judge venue rule. Oh my God, now she's trying to get the chief justice removed. The balls on that woman.
Really finding where they are specifically in the Jeep isn't really an indication that something happened. It was just finding any in the Jeep. So it doesn't really matter where they originated or where I found them. It's just that they were present.
Okay, so you're really just looking to see, are those characteristic particles present within this Jeep that would indicate that a gun may have been discharged within that vehicle?
That is correct.
So we talked about 2 of the 3 vials. Was the 3rd vial the driver's side interior window?
Yes.
Did you find particles commonly associated with GSR on that vial from the driver's side interior window?
Yes, I did.
Did you find particles consistent with GSR on that driver's side interior window?
Yes.
And did you find particles characteristic of GSR on that driver's side passenger or driver's side interior window?
Yes, I did.
When you then were looking at all 3 of those in different areas within that Jeep, were you then able to reach an overall conclusion as to this vehicle where these kits were taken from?
Yes, I was.
What was your conclusion?
that the inside of the vehicle was again in the vicinity of a firearm when it was discharged or came into contact with an item that had GSR on it.
And then given the locations of the collection sites, that was done to try to look for places where potentially the areas may not have been washed?
Correct.
And when you were talking about something coming into contact with those locations, are you also thinking about the fact that if someone puts a gun in their car, it's not usually on a window?
Correct. I wouldn't test like the back seat of a vehicle knowing that someone used that vehicle to go hunting or go to a shooting range in case they put their firearm in the back of their vehicle.
So if the collection had only been, for instance, of the seats of the vehicles, that may have that may have played into your conclusion some?
My first initial analysis, yes.
In this case, because you were looking at windows in this vehicle, were those stubs specifically chosen by you because they were the windows that were collected?
Yes.
I have no other questions for this witness.
All right, Cross.
Just a few questions. Mr. Mueller,
Sorry, guys, just put some soup in. I'll have to go get it, but I'm monitoring. We're good.
you had said that a gun may have been discharged in this vehicle. Is that your conclusion?
Yes.
Okay. And just so I understand, because I'm trying to wrap my head around that, the three particles altogether, right?
Yes.
Antimony, barium, and lead, all three make it actually GSR. Is that correct?
So there's three classifications. All three of those elements in one particle is considered a characteristic particle, which is considered a GSR particle. But there's also the 2 component and the 1 component particles that I detected are also considered GSR.
Right. And so in your report, you say they're also found from a number of relatively common non-firearm sources. Is that also correct?
It's possible, yes.
And what are the non-firearm sources? Could you tell me some of those?
Sure. For lead, lead used to be prominent in gasoline and paint years ago. Lead can still be used in solder or varying manufacturing facilities. The 2 component particles are less common, but they also can be found in maybe some cosmetics or fireworks. But again, those are less common.
Okay. So would you find an actual GSR where all three elements were together in fireworks? Like if a firework went off in the vicinity?
No, ma'am.
You would never find GSR after fireworks?
3 component particle, no.
So you would find either consistent or commonly associated?
It's possible depending on the firework.
Okay. What about from brake dust?
Again, that's possible, yes.
What about from fertilizer?
I'm not familiar with fertilizer having those specific elements.
What about hairspray?
I'm not familiar with hairspray being a component or having those components.
Okay. So of the kits that you took, of the stubs that you had that you actually tested, how many all three particles did you find together, grouped together?
So 2, one on the driver's side and one on the passenger side on the inside windows.
So just 2?
Correct.
And so if a firearm were to be shot in the back of the Jeep, would you expect to find more than 2 from all the stubs that you analyzed?
It's difficult to determine how many particles are actually there. I'm essentially getting a sample of that area. So the number is not really pertinent to my analysis.
So is it safe to say that whoever was the person who got the stubs would be deciding what you would end up analyzing later? You wouldn't have any control over that, right?
Correct. I didn't collect the stubs.
Okay. So out of the 2 that you found, out of how many stubs did you actually analyze? I'm sorry, I missed that.
So I analyzed 3. In total, there were 8 collected.
Okay. That's all, Your Honor.
Redirect.
Just briefly. For the characteristic particles with all 3 elements, did you find one of those in the passenger side interior back window?
Yes.
And did you find 2 of those characteristic particles in the driver's side interior window?
Yes, I did.
You were asked about some different things like hairspray and brake dust. Are those things that would create the 3-particle characteristic items that we're talking about that are characteristic of GSR?
No, they would not.
So no matter how much hairspray we use in the car, you're not going to get antimony, barium, and lead stuck together into a particle?
No,
No matter how many fireworks we blow off in the back of this Jeep, we're not going to get the antimony, the barium, and the lead together as a characteristic particle?
no, ma'am.
So is this why it doesn't really matter how many you find? The fact that it's there is what's important?
Correct.
Because when you find the particles that have all 3 of those, that is what's the most meaningful of all of this.
Yes.
And that's because for the single, just lead, we could come up with some reason why that might be there, right?
Correct.
And for even the consistent with, maybe you can come up with some reasons why it's there.
Correct.
But when we start talking about those characteristic particles, that means it's gunshot residue.
Correct. And the reason why I list out the other 2 classes, if you will, the consistent and commonly associated with, is because I expect to see all 3 types in the discharge of a firearm.
So when we are looking for the discharge of a firearm in a, we'll call it vehicle, as we were talking about here, you wouldn't expect to only find the characteristic particles.
No, I would not.
You would expect to find the single particles, the 2 combination, and all 3 together.
That's correct.
Exactly what you found here.
Correct.
I have no other questions.
Are there any questions for this witness from any member of the jury? Don't see any, sir. You can step down.
Thank you.
State can call its next witness.
Thank you.
All right, sir, come on up. You're going to stand right here in front of my clerk, be sworn in.
Can you please spell your first and last name? Do you swear that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, you're going to walk around the court reporter. Have a seat to my left.
Would you please introduce yourself to the jury?
My name is Ray Hermosillo. I'm employed with the Rexburg Police Department.
Where is Rexburg Police Department?
Rexburg is a little town in southeast Idaho.
How long have you worked for the Rexburg Police Department?
I've been with Rexburg since 2001.
And can you tell us your different jobs or duties over the years at that department?
Sure. I started in patrol in 2001 as a normal patrolman. I worked patrol for about 18 years before I was promoted to detective in 2019. During that 18 years, I was able to obtain numerous certificates. I currently hold a supervisor certificate and an advanced certificate through Post Academy. In 2019, I was promoted to detective. I currently am a lieutenant over the detective division.
So in 2019, you were working as a detective in Rexburg. How big is that city?
Rexburg is roughly probably 40,000.
Okay. How many detectives are there?
Currently, we have 7 detectives for the 40,000 people.
And back in 2019?
About the same, 7.
And did you cover sort of any investigations in every investigation as a detective in Rexburg?
Yes, ma'am.
I want to bring you to November 1st of 2019. Did you speak with a detective, Nolan McDermott, from the Gilbert Police Department here in Arizona?
I did.
Were you asked to aid the Gilbert Police Department by locating and impounding a 2018 Jeep Wrangler with a Texas license plate LWD 0997?
Yes, ma'am.
Were you provided with an address where that Jeep might be located?
I was.
Are you familiar with 565 Pioneer Road?
Yes, Rock Creek townhomes.
Okay, so those are townhomes. Are there multiple units there?
Correct.
Were you provided with a unit 175 that would potentially be relevant to this case?
Yes, I was told that 175 was where I needed to focus, 175, 174.
When you were given this information, were you provided with a probable cause statement from Detective McDermott?
I was on November 1st of 2019.
And knowing that you were going to be looking for this Jeep to seize it, did you obtain a search warrant?
Yes, I did.
So on November 1st, did you go out to 565 Pioneer Road, Unit
did.
175?
Yes, we did.
Did you go with someone else?
I'm sorry, could
Sure.
you repeat that?
Did you go with someone else or were you by yourself?
No, I went with other detectives.
And what did you do when you got out there?
We were asked by Gilbert Police to perform intermittent surveillance to see if we could locate the 2018 Jeep Wrangler. So that's exactly what we did. We went out, performed surveillance, and we were unable to locate the Jeep on November 1st.
Now, had you been provided with the name Lori Vallow?
Yes.
Had you been provided with the name Alexander Cox?
Yes, we have.
Were you looking for the Jeep that belonged to Lori Vallow?
Correct.
Okay. When you were doing surveillance of Unit 175, did you take any photos of the individuals who you saw going into and out of that residence?
We did. We took a couple photos of some individuals coming out of the garage and going into the garage area of 175.
Did you see that person go into any vehicles?
We did.
Was that a male or female you saw?
That was a female, Lori Vallow.
Do you see that person that you saw going in and out of Unit 175 and getting in and out of the vehicle that you saw in Rexburg, Idaho on November 1st in the courtroom today?
Yes, I do.
Can you point her out and tell us what she's wearing?
She is at the defendant's table in a blue coat with a light blue shirt and red glasses.
Your Honor, may the record reflect the witnesses identified the defendant.
Lucho.
Did you, in fact, follow Ms. Vallow in a vehicle to another location and back to the Unit 175?
We did. We followed her to Walgreens in Rexburg off of Main Street, and then followed her back to her residence at 175.
What kind of vehicle was she driving at that time?
A blue Nissan Rogue.
Okay. I've shown defendant exhibits 126 and 127. I may have my paralegal approach. And did you said you took photos of those. I'm showing you 126 and 127. Can you let me know if you recognize those? Do you recognize those as photos taken from surveillance on November 1st of 2019?
Yes, ma'am.
State will move to admit 126 and 127.
Any objection?
Just relevant, Your Honor.
They're admitted. 126, 127.
Now, you told us that, if I can have the Elmo, that the defendant, Ms. Vallow, was driving a blue Nissan Rogue. Did that have an Arizona license plate of CRT 2994?
Yes, ma'am.
We're showing here exhibit 126. I'm going to pull out some. Although we can't really see well. When there's no glare, is Ms. Vallow going into the residence here?
That is correct. That's Miss Vallow.
And this is Unit 175.
Correct.
And then 127 is her going further into it, albeit the glare here, we can't really see that.
Yes, ma'am.
So did you find the Jeep that you were looking for, that 2018 Jeep with the Texas plates when you were there on November 1st?
No, we did not. Not on November 1st.
Did you search the whole complex?
We did.
So did you go back again later to try to locate the Jeep?
Yes, we looked for the Jeep. November 1st was a Friday in 2019. We looked for the Jeep all weekend and were unable to locate it. I was finally able to locate it Monday morning, November 4th.
So did you went back to look again on Monday morning to 565 Pioneer Road and you saw the Jeep?
I was on my way home from the gym and looked over to my right and saw the Jeep parked outside of apartment 175.
What did you do when you saw it?
I had Erickson Tow Company seize the Jeep and tow it to our impound lot.
Is that an internal or external lot?
We have both external and internal, but we towed it and put it inside our impound lot, inside.
Did you let the Gilbert Police Department know you had located and seized that Jeep?
Yes, ma'am, we did.
Did you attempt to contact Lori Vallow to let her know you took the Jeep?
We did several times that day. We made attempts to go over and knock on the door to let Miss Vallow know that we had her Jeep in case they wondered if it was stolen or impounded. And we were unable at any time to make contact with Miss Vallow, and nobody had called the police department stating their Jeep was missing either.
So you never received a call from Lori Vallow to report her Jeep stolen?
No,
Never got a call from Alex Cox saying a Jeep was stolen?
no.
So you have the Jeep on the 4th of November. Do you coordinate with the Gilbert Police Department for them to come to Rexburg, Idaho to be able to process the Jeep?
We did.
Did you in fact author the search warrant for them to be able to take things like DNA swabs and GSR kits and things like that?
Yes.
Were you present when that search warrant was executed on November 18th of 2019?
Yes, I was.
Were you just watching and allowing them to do the processing?
That's correct.
When you were there on November 18th, as well as when you impounded the Jeep, did you note anything about the tinting on the rear windows of that Jeep?
I noticed that the tinting on the Jeep was extremely dark. It appeared darker than Idaho state law allows.
From the outside, trying to look inside, were you able to see into the vehicle?
Not unless I got right up to the window.
Did you learn during,
The tent was rated at 5%, meaning only 5% of sunlight could come through. That was so dark that if you walked up to it, you couldn't see somebody on the other side of that glass. Yeah, that was illegal, people.
this investigation that that Jeep had been taken to Dan Moss's tinting on September 25th to have those windows tinted?
I did learn that later on in the investigation, yes.
Okay, but at that time you did not know that.
That's correct.
On December 18th of 2019 was a second search warrant executed on that Jeep Wrangler.
Yes, ma'am.
Did you author that search warrant as well?
I did.
And were you again present for the execution of that search warrant?
Yes, I was.
Were photographs taken of the Jeep?
Yes, they were.
Were photographs taken of receipts inside the Jeep?
Yes.
When the Jeep was being processed on December 18th and photographs were taken of the receipts, did you note a receipt inside that was related to, or that came from Arizona?
Yes, I did.
Did you notice a receipt from Arizona that was from October 1st of 2019?
Yes, I did.
Understanding that you were being asked by the Gilbert Police to investigate a shooting on October 2nd, did you feel that was relevant?
Yes, ma'am.
Shown the defendant exhibits 128 through 134, if I can have my paralegal approach. Do you recognize those as photos taken of the Jeep from the search warrant that was executed on December 18th of 2019?
Yes, ma'am.
State will move to admit 128 through 134.
Any objection?
No objection.
128 through 134 admitted.
So 128, were these just some overall photos of this Jeep?
Yes, that's correct.
In 129, do we see a tag from Texas that also reflects the license plate number up here, the LWD 0997?
Yes.
Is this, again, the side to show that dark tinting on that?
Correct.
That's the license plate that was on the Jeep that you impounded?
Yes, ma'am.
Does that show the whole back of the Jeep?
Yes.
I know you were present both on November 18th and now on December 18th, a month later. When this Jeep was being processed with this tire on it, were you guys able to open that rear window while the tire was still on the Jeep?
No, we weren't able to.
And then is this the other side of the Jeep itself?
Correct.
In Exhibit 134, does this show sort of different receipts and stuff found in the Jeep itself?
Yes.
And does that include, focus? A receipt from Los Favoritos at 5351 South Power Road in Mesa, Arizona?
Correct.
And does it show a date of October 1 of 2019?
Yes.
And although it's getting blurry here, is it the timestamp 1312 hours?
Yes, it is.
So this receipt, let me ask you this. From the time that you impounded the Jeep on November 4th, was it always in your custody until this executed?
Yes, you guys may not have remembered that, but yes, he had the windows tinted just before the event on October 1st of 19 is when he had, no, I'm sorry. That's when they were towed. A short time prior to the event, the guy yesterday was on the stand and the one that put the tent on it, and the number of the tent's like 30, level 30% of the sun gets through. 5% of the sun gets through. 5 is one of the darkest tints you can put on there other than 100% blackout. So yeah, they were modifying this Jeep. They took the back seat out. They took the tire off. They tinted the windows to a point that you couldn't see anybody in the vehicle if you were standing looking at it like this. Yep.
Search warrant on December 18th.
Yes, it was.
And so this Jeep that you impounded on November 4th had a receipt from October 1st of 2019 at 13:12 hours from a restaurant in Mesa, Arizona.
That's correct.
And you were aware at that time that Brandon Boudreaux had been shot at on October 2nd of 2019?
Yes, ma'am.
So this was from the day before.
Right.
Squeaky wheel, if you're here, please do me a favor and say hello again. I don't know why you're not showing up in comments on YouTube, but you are showing up in my StreamYard.
When you were working with the Gilbert Police Department,
I'm going to speed this
you told
up a
us that
little
you
bit.
had done some
You're talking too
surveillance
dang slow.
from November 1st until you recovered the Jeep on November 4th. Later in November, did you have some additional time to do surveillance at the 565 Pioneer Road, specifically November 26th?
Yes, we did.
On November 26th, did you have contact with a person by the name of Chad Daybell?
Yes, I did.
On November 26th of 2019, who did you understand that to be in relation to Lori Vallow?
Lori's current husband.
Was there anyone with Chad Daybell when you saw him on November 26th?
It was also Lori's brother, Alex Cox, that was with Chad Daybell at that time.
Can you describe for us the circumstance you saw these two on November 26th? Where were they? Were they around a vehicle, around a townhome?
So when we made contact with Chad, and Alex, they were unloading Alex's pickup truck, unloading items from the back of it into the garage of apartment 175. And that's when I initially made contact with both of them.
You said that they were getting out of a vehicle. What kind of vehicle was it?
It was a gold Ford pickup truck.
Was it a Ford F-150?
Yes,
Do you recall if it had Arizona plates on it?
it did have Arizona plates. I
Were
believe
they, I guess, personalized plates?
they were personalized.
Was that a CPQUINT?
Yes, CP Quint.
At this time, when you are at this apartment complex on November 26th, is it your understanding that Lori Vallow is living at those Rock Creek townhomes?
That's correct.
Was it your understanding at that time that Alex Cox was living in the Rock Creek townhomes as well on November 26th?
At that time, yes, we knew he was at the Rock Creek townhomes.
I've shown the defendant exhibit 135. I get my legal approach.
Thank you.
Is that just sort of an aerial overview of the Rock Creek apartments that we're talking about
Yes, it is.
at 565 Pioneer Road?
Yes, ma'am.
And does that show where unit 175 is?
It does.
State will move to admit 135.
Any objection?
Just foundation, Your Honor.
135 is admitted.
Okay. So we see here, this is Pioneer Road. Is this the Rock Creek townhomes?
Yes, it is.
Using exhibit 135, are you able to tell us approximately where unit 175 is located?
Is there a pointer I can use or?
Could he point to the TV behind you?
Look behind.
If you could get up and,
Go ahead.
thank you. So if you could point to, yeah,
175, the back 175 is roughly here, and the front door is this way. So the garage, where I first made contact with Alex and
Hey, June, your order has shipped. Just FYI.
Chad both.
Your
Right
order
back
has
here.
shipped.
Detective, maybe
Yay.
if you go to this side. Sorry, just the other side so the jury doesn't have to look through you. Thank you.
The Jeep was located on November 4th, parked in a stall right here.
So that's where you located it on the 4th. And that's right near the 175 you're describing?
Correct, right in front of the 175 garage.
Now, you told us that you also knew that at that time Alex Cox was living at the Rock Creek Townhomes. Can you show us where that was, what unit that was, approximately?
107 is where Alex Cox was living, and it was roughly here, the front door of 107.
Okay. During this time, on November 26th, did you learn that Melanie Boudreau was also living at the Rock Creek Townhomes?
Yes, I did.
What unit did she live in?
She lived in 174, which is right next door to Ms. Ballard's residence at 175.
Thank you. You can be seated now.
Yes,
Now,
please leave your DNA. Thank you so much.
Did you become, I guess, were documentation obtained along with an affidavit for the rental application for Lori Vallow to live at 565 Pioneer Road?
Yes, they were.
Did the documentation show her as renting unit 107?
Yes, it showed Lori Vallow as the renter of apartment 107.
Did you ever see her over at apartment 107?
No, I didn't.
So on November 1st, you saw her at 175?
Crack my neck.
That's correct.
Oh, great.
Your Honor, this case will move to admit Exhibit 162, which is pursuant to 803 and 902 with the affidavit authenticating them from the custodian of records.
All right. Any objection?
No objection.
Can you give me the number again?
162.
162 is admitted.
So 162, we see the application for Lori Vallow to rent 565 Pioneer Road, number 7. Is that correct?
Number 107, yes.
107. And that was submitted on August 14th?
Correct, the way I understand it.
And did that indicate a vehicle of a Jeep Wrangler with the LWD 0997?
Yes,
That's the Jeep that you impounded on the 4th?
that's correct.
And did it also indicate a Nissan Rogue Blue, no license plate at that time?
Correct.
And is that the type of vehicle that you had seen Lori Vallow driving when you were doing surveillance on the 1st of November?
Yes, ma'am.
Now, you told us that Alex Cox also lived in this townhome complex. Is that correct?
That's correct.
And do you know if, what unit he rented in his paperwork? Was it 175?
Yes, Alex was a renter in apartment 175.
Now, we're talking about November 26, where you're doing some surveillance. You have interactions with Chad Daybell and with Alex Cox outside of Unit 175.
Correct.
Did you go to Unit 105 to see if Lori Vallow was there?
We went to unit 107
107, yeah, I'm sorry.
to see if Lori was there, and there was nobody there at that apartment.
Were you aware then that the rental paperwork for Alex Cox, along with an affidavit authenticating those records being kept in the normal course of business, was obtained from the Rooftop Real Estate Management Company for Alex Cox's rental of Unit 175?
Yes, we didn't obtain that on the 26th of November, but later throughout the investigation, yes, ma'am.
Correct. State will move to admit those pursuant to 803 and 902, Exhibit 160.
Any objection?
No objection.
160 is admitted.
And so, although this is a tough thing to read, do we see the 26th day of August of 2019, Alexander Cox?
Yes.
And does the letter from the Realty Management say that Alex Cox had rented 565 Pioneer at Unit 175?
That's correct.
Yo, I just keep shaking
Now,
my
you told us
head.
that on the 26th of November, you had contact with Chad Daybell and Alex Cox near Unit 175. Did you go to Unit 175 to see if anyone was inside there?
We knocked on apartment 175. We also knocked on apartment 174, which is where Lori's niece lived, to see if maybe they were over there. And we were unable to make contact with anybody at all three apartments.
Okay. Now, the next day on November 27th, were search warrants executed on Units 107, 174, and 175?
Yes, they were.
Was anyone home in any three of these residences when they were executed?
No, there was not.
I'm going to talk about Unit 107, the one that was in the rental paperwork rented to Lori Vallow. Can you describe for us what you saw when you went into that unit?
Apartment 107 was completely vacant. It looked like everybody had moved out. There wasn't anything in the entire apartment. So We assumed that nobody had lived there because it was vacant.
So no furniture,
No, ma'am.
no groceries?
Nothing. Like it was ready to be moved in for a new tenant.
Okay. When you went into unit 175, where you had seen Miss Vallow going into previously after making the trip to the Walgreens on November 1st, what did it look like inside that unit?
So 175 was different. There was furniture, food in the pantry, food in the refrigerator, beds. It looked like somebody was living there. But as we went upstairs into the master bedroom and other bedrooms, the entire closet was completely empty, other than just empty hangers. So it looked like somebody had just grabbed everything hanging. There were no clothes and just took off with what they had.
Let's
Were
go.
photographs taken
Grab and go.
inside unit 565 of Pioneer, or I'm sorry, 565 Pioneer Road, unit 175 during that search warrant?
Yes, photos and also a video.
Okay. Did each of these units have their own garage as well?
They did.
So I'm going to start with the interior of that residence. When you were inside unit 175, did you see any documentation in there relating to renting a storage unit for Lori Vallow?
Yes, we did. We found a rental agreement in the master bedroom on what I believe to be was a copier, where it detailed the address of the storage unit, self-storage plus, and also the storage unit number, which was C52.
Your Honor, I've shown the defendant Exhibit 136 through 138, if my paralegal can approach.
Thank you.
And is that showing, sir, the outside of the unit and then a photograph of that document that you located that you just told us about?
Yes, ma'am.
State will move to admit 136 through 138.
Any objection?
No objection.
136 through 138 are admitted.
Okay. So 137, do we see the front of units 175? Oops,
Yes, cut off.
May I pull out?
There you go. Yes, 175. It's the one with the toys out front.
where would 174 be in relation to this?
To the left of that apartment.
So
Yep,
this
right
one?
over there.
Okay.
Yes, ma'am.
So this apartment was technically rented to Alex Cox, but inside it had some indicia of Lori Vallow.
That's correct.
And I'm putting up 138. So when we see this, we see at the top, you said C52. Is that a storage unit location?
That's the number of the storage unit at the storage location, correct?
Okay. And down here, do we see a date when this was executed?
Yes, October 1st, 2019.
And what name is on this?
Lori Ryan.
Did you learn in your investigation that Lori Vallow, before she became Lori Vallow, was Lori Ryan?
That's correct.
So she was Lori Ryan, then Lori Vallow, and now Lori Davis.
So she's using a wrong name. Once she went to Vallow, she can't use Ryan.
Correct.
That's strange.
Does this show the location of the storage facility?
Yes, it does.
Self-storage plus at 433 Airport Road?
Yes, ma'am.
Where is that in relation to 565 Pioneer Road? Is it far away?
No, it's roughly probably a half a mile north. If you stay on Pioneer, you'll run right into Airport Road. It is on the north side of Main Street, so about half a mile away.
Inside the residence, did you see any like women's clothing or anything else like that that appeared to be consistent with Lori Vallow? And I know you told us most of it was gone.
We found women's clothing in the garage in apartment 175.
So in the garage, can you describe for us what the garage was like? I mean, what did you see when you went into the garage? Was there cars in there?
No, so in the garage of 175, there were boxes. It appeared people had been moving things into the garage of 175. So there were plastic containers full of various items. There were boxes full of clothes. There were prepper barrels for water storage. Just various different things that it looked like people had moved in.
So in addition to having furniture and clothing and all sorts of stuff, did you find any paperwork in the garage that was related to Alex Cox?
We did.
Things like passports and bills.
Correct.
Did you find any weapons in the garage?
We found several weapons in the garage, yes.
Now, since you were working with the Gilbert Police Department, had you been advised that Brandon Boudreaux had seen a rifle barrel
card.
come out of the Jeep Wrangler and then fire at him?
Correct.
So were you looking for any rifles when you were going through that garage?
Yes, we were.
Did you photograph all of those?
We did.
I've shown defendant exhibits 139 through 159. If I can have my paralegal approach.
Go ahead.
Yep. I love my commemorative 75th anniversary Whataburger mug cup.
Do you recognize all of those as photos of sort of the indicia of Alex Cox, as well as the various weapons that were located in the garage of Unit 175?
Yes, ma'am.
The state will move to admit 139 through 159.
Any objection?
Just cumulative, Your Honor. There's like 20 something of those. I don't know how many they actually need.
Can I look at them?
Oh, you don't like it, Lori? They're all properly admitted. If you guys don't know, we now have merch. In my humble opinion, I'm a hope.
All right, they're admitted.
So, and I think I called you detective earlier. I apologize, Lieutenant. To be clear, Unit 175 was rented by Alex Cox, correct?
Correct.
But on November 1st, you saw
Okay,
Lori Vallow.
we're going to pause. We're back in court. We are back in court. Turn on the sound. I wonder who that woman is. Just saying. Don't have any sound. Okay, here we go.
Dr. Rentschler, you wrote a report back in February 2024,
That's correct, yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying
Don't get catty.
any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes.
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same. No, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the pink test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
I'm going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The
yes.
question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were, let's see. Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that. Correct?
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It looks at, it tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cuttability and its Relation to Lacerations Severity Indices. You know that, you cited that.
That's correct, and it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cuttability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree
And
that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
I don't know why he's hammering this, because he's asking the same question over and over again, expecting a different response. You got your answer, now move on.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr.
He's holding
Welcher's
his own well.
pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that the arm was positioned?
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished or
I'm
represented.
asking you, you've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
Do you
You're correct.
know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
If you don't have the
You can-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
so if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of
I was hired to debunk your expert witness. And he did a pretty good job,
scientific certainty, would it?
in my humble opinion.
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
Oh, so now he's saying, if you're asking me if we knew exactly where and how and when and this guy was standing, and we do not, then you can't concur that it actually happened. Scientifically not possible. If you don't know point A, B, C, and D, then how do you know it happened at all? It's kind of a point, if I understood that right.
So,
That's a point. If Dr. Welcher didn't have the same information, how was he able to do the paint test? That means that Dr. Welcher made assumptions too. They're all making
if an
assumptions.
expert,
This whole case is based on assumptions. Nobody has any idea whether he was truly facing the car, his back was to the car, was he sideways? It's all a hypothesis and assumptions. So you can't get after the defense's expert witness for the same thing that you've done. That bothers me.
does a crash test, and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm going to, very briefly.
Okay, y'all. So we have
Sidebar.
a sidebar. I wish you could hear my dog noises. I downloaded growling dogs, and you can't hear it, and it breaks my heart. Breaks my heart. You can't hit it, man. Yeah, there's assumptions all around. All around. I am trying to fix my sound problem. I've been having a sound problem. And I don't know why. I don't know why you cannot hear. How about this? Can y'all hear that? I was hoping you'd hear it. Come on, get your sound
In
back.
reading the
Sound back on
reports
record.
and evaluating the power possible to
What
predict.
the hell just happened?
I suppose.
Are y'all hearing sound? Because I'm not.
I probably have.
I have
I mean, it
sound now.
depends. If you don't know what happened,
y'all
sure,
have
then you
sound?
don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables
I need someone
that
to tell
sometimes
me.
you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did
Got
not,
it.
no.
Were you even there when they happened?
I was not, no,
Not
sir.
sound.
So you're relying in part on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction, it's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually, it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
You've seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move. Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
If you answer my question.
I just did answer it. I said
Objection, Your Honor. Argumentative.
it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move it the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision, isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Rentral's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes,
And you put snippets up on the board?
yes,
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet, and these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions, because that is the majority of pedestrian collisions, the front end, isn't it?
The majority, it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct, and that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different, and doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour.
No,
just
it didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no.
You
I
don't-
don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle,
He's
So,
right, none of them
Ask the
know.
question again.
Okay. You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
we have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
And when you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please? let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
That was the load at the center of mass. And so you can evaluate that.
Okay, Brennan, you're getting ready to lose your jury if you haven't lost them already. When you ask these questions, like, well, was this what was it called? A concentrated or distributed load? You need to explain what that is because your jury is not going to know. One thing that frustrates me with these lawyers is they are using all these fancy words without describing what the hell they are. And the thing is not everybody in that jury is going to know what that is. So you need to ask him, what is a quantitative, what is a distributed load? Clarify that for the jury, please. Then ask your question. You're throwing out words and theories and concepts and technical words that your jury's not going to know. So are you going to lose them?
On a distributed load, you look at acceleration and you look at bending moment. So you can do both.
I mean,
When
he's
you
somewhat
gave your
trying
charts
to
and numbers, was that
describe
based
it,
on
but
concentrated
give it to them up front so they can follow along.
or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
But we're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand.
So
But center of mass, acceleration, and distributed across the entire arm,
Exactly.
that's where it's the,
Yes, they always need to assume. Some people may know, but the vast majority of them may not. All I'm saying. Lunch is here.
the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There's a difference between taking a small object and putting
Pizza.
pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
Yep, I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again, did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Were those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's in a...
Excuse me, sir. in a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight is shattered?
I have, yes.
In fact, in your video, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have Exhibit
individual.
73, please? Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't, was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical?
He just went there. Guys, I'm not a lawyer. I'm just an average person. Yep. Aaron, we're sisters, man. We're sisters. Okay. Jeez. Brennan is wanting him to admit that he could not. Nope, he can't tell where the arm was, therefore his tests are inconclusive. But Brennan, what you're doing, if I'm sitting on the jury and I'm hearing you do this, I'm thinking, but neither can your expert. Therefore, if I put his information 100% out of the ballpark, meaning I can't consider it because he didn't know where the impact and how it actually, happened. I ate too fast. Neither can you. So does that mean we can't prove impact? If we can't prove the impact, we don't have a case.
Mechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have Exhibit 76A, please?
I love pineapple, but I sometimes eat too much and then I get mouth sores.
You see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight
I'm
shard?
sorry, Truth.
It looks like it,
Mom.
yes.
Did you consider this in your biomechanical studies, that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found?
There
and
you
where that was
go.
found with respect to Mr. O'Keefe, with respect to a reference point?
No,
Did you
you
consider
cannot.
this, sir?
There is none, so no, I did not consider that.
Do you know how this taillight shard got there?
See, that's part of the problem. The police did not measure. They did not map it. They did not graph it. They did none of the above. So anyway, our cat is misbehaving, and I think it's because somebody disappeared and she didn't know what's going on. And she's being here alone a lot more. So anyway, so if they did not do any of the measuring, mapping, graphing of all the pieces in comparison to the car and the body, which they did not, he cannot sit there and affirmatively say that that piece of tail light came from the impact because he doesn't even know where it is. It's just a picture of a tail light piece of plastic in the snow. There's no chain of evidence at all. None. I mean, there's no connection.
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 990.
Hey. Yeah. Hey, Jin. I love,
You
by
know
the
what that
way,
is, sir?
Jin, I have had the dance tuxedo, which is the jacket, the top hat, the bottoms, the hose, the shoes. I've had that outfit and I loved it.
It looks like part of the light assembly.
Mr. O'Keefe's hat.
Welcome, Jen.
that's
Look at
his
this
hat.
photograph.
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
Just like he did with the doctor, not his expertise.
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose
Agreed.
that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when
said
or
it.
how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's
so it
immaterial
begins.
to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that where we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that it refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please.
And
Have you
so
seen this
it
photograph?
begins.
I have, yes.
Okay. In your studies or your testing, did you determine how
See,
Mr.
that's what bothers me about this case. I'm not trying to sit here and say Karen Reed is 100% innocent. I'm not going to do that. I won't. I mean, I'll play both sides of the coin, but I'm not even looking at innocence and guilt on Karen Reed because number one, how did the hat get there? Anybody see how it got there? Number two, the shoe, how did it get there? Did anybody see the impact? I mean, there's just not any evidence that says that Karen Reed behind the wheel of that SUV actually did all that they're accusing her of. And I find it interesting that the shoe was up against the curb. The shoe was up against the curb or the burn, whatever you want to call it. And the hat was in the yard underneath all of the snow. That much snow. Totally underneath it. I have a problem with that. I don't know. There's nothing out there that tells us how it got there. So to me, you have to err on the side of the defendant because the prosecution has to prove everything beyond a reasonable doubt. How do you prove how that hat got there beyond a reasonable doubt when there's no evidence to show? There's no witnesses. There's nothing. She could have done it. but it's about what the state can prove. And at this point, all they have shown, and there's no video, and that's something else I find interesting. They have video on the phone of one of the police officers using the blower, the leaf blower. I love this. Let me get my voice on, y'all.
Duh. George, look at me. I'm using a blower. Isn't it so cool? Hurry up and film me so we can show everybody what a great idea this is. Oh my God, we're so smart for redneck.
No, that's how I feel about that, because it's like you will take the time to video people pulling off a stupidity using a leaf blower that's contaminated on a crime scene. I see you doing that, but you won't take 5 minutes to do a video recording with tape measures where all this evidence is being found in connection to the body. I know it's cold. I know it's wind is blowing. I know you're in what you call a blizzard, but still, because it's lost. You cannot prove anything at this point at all.
O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photo?
But my point is if you're going to have a video of you doing anything at a crime scene, you video all of it, not just a part of it. Why didn't you just do a quick video of the scene the moment the body was removed? Nothing disturbed. Do a video of the hat being found. Because your video, have it set up where you film your investigation. Have a video camera sitting there watching you do the work. And then you see, as you're digging, we have this, but we don't have any of that. So my problem is, if you think you're smart enough to video someone using a leaf blower, you should have done more to preserve the evidence and film video your process in that collection.
Photographed before.
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that were recovered from Mr. O'Keefe's sweater or shirt?
Objection. I'm going to allow that. Did you consider that?
I'll try. I'd rather try to reformat it than come sidebar. Did you know that taillight shards were collected after Mr.
So many
O'Keefe's
more
sweatshirt
people.
and T-shirt was scraped?
Objection. I'm going to allow that. Jurors, this will be brief.
Sidebar. Sorry, let me get my fan off. Okay, I'm just saying they could have done a whole lot more to preserve their evidence and the process. I talked to somebody and I keep referring to them as my evidence queen. She was an evidence in charge of the evidence and investigator and evidence and all that in the Boston PD for a while. And what she said is what normally they would have done in incumbent weather is get a video camera out or a phone and film it like instantly. Start filming everything. Just start videoing everything and putting a ruler down. They all should have rulers in their cars. Putting a ruler down and videoing, put the ruler next to the hat and video it. Take a tape measure, string it from the curb to the body, from the curb to the hat, from the curb. I mean, just zip, 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 zip. You can quickly do this. Now it's hard to get a tent. And I asked her, I said, what if they got a tarp, a clean tarp, forensic tarp, and just covered that entire area? And then the snow would fall on top of the tarp. Then they go back and they remove the tarp with the snow, and they're left with the exact pristine level of snow and evidence that was there to begin with. He goes, yeah, that would have been
In
smart.
your
I'm like, I'm
extensive
not even
study
a
of the
CSI, and I
detail of
couldn't
this
think of
case,
that.
did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his t-shirt? Did you know that?
I was
doormat.
aware that samples were recovered, yes.
Were you aware that these samples were consistent
Just shut your door.
with the broken taillight of Miss Reed's Lexus? Did you know
The
that?
cat's acting out.
Yes.
I'll be
Did you
back.
do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Your Honor, based on the last question, I want to let Dr. finish his question. I'm objecting you to try based on the question that was asked. For the same reason I just indicated the sidebar. You just reformatted it. Sure.
I'll try again.
Okay.
When you looked at these taillight shards that were
Objection. That's the problem.
Go ahead, Mr. Brennan.
when you looked at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection.
I understand the objection. Word it differently. Start with the different word.
Yes, Your Honor. You see these
Get on the mic.
pieces of broken plastic, don't you?
I do.
And you understand that these were found in scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic
Mhm.
are consistent with the taillight of Miss Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Please.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well, if
that?
that's what you're
I don't,
telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph.
Does that change your
you see these
opinion?
broken pieces of plastic
No.
Under a microscope with fibers near the plastic. Is that something you would want to consider in your analysis, forming your opinion whether or not there was a collision between Miss Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
Well, I don't have an opinion as to that, sir.
We'll take a look.
Objection.
Sustain.
If you look at that for me kindly, can you tell me whether you think those pieces of broken plastic are sharp?
Objection.
I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than
Okay, let's go back to
looking at the normal eye.
20E. Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please? Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no.
A drinking glass, no?
No.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, Those red things falling down, what are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you moved the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
Objection.
No, I'm going to allow that.
You do not know how
Understand
John
that.
O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
And that's the thing I don't like about Dr. Welcher having the right to come back, because now they get a second bite at this apple. And the thing is if I was Brennan, I'd be asking the same questions of Welcher. You don't know what angle of the arm was. You don't know which direction and how he was standing. Mr. Brennan himself asked and stated that nobody knows how any of his position of his body at the time of this alleged impact. In fact, there's nobody that knows for sure the car actually hit him. You can't sit here and say beyond a reasonable doubt a vehicle hit him. I would be hammering that like crazy with Brennan. I mean, with Welcher.
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
What do you mean consistent or
Is
different?
it all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall.
Well, and here's the thing. The state has alleged for all these years that O'Keefe was struck by the vehicle, fell backwards, hit his head on the ground that was frozen and hard as a rock, causing the head injury. And then their people, Welcher, did a test and said the back of his head hit the spoiler, which is not possible because the curvature of the vehicle, if you're 6 foot tall, here's the curvature of the vehicle. I don't know how to do this. Curvature of the vehicle, right? And you got a spoiler and you're 6'2". When your head goes back, it goes lower. It doesn't get higher. You go lower than your actual body height. You shrink in height when you bend. So now, in order to actually do what they're saying, you would have to grow a few inches when you fall backwards. And they're changing their theory in the middle. You've got one of their witnesses saying his head hit the ground and the ground was hard as a rock. And that's what caused the head trauma. And that's why he died. And then you got somebody else saying he hit the spoiler of a vehicle. I hope they touch on that on closing.
All right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Okay. Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct.
And you see in your test that the tail light, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light?
I tell you what, Brennan, what we'll do is we'll have you standing on the curb or the burn right there where you think John O'Keefe was. We'll have Karen Reed get in her vehicle and the snow. We'll wait for the next big snowfall and we'll have her back up 25 miles an hour, 24, whatever number you want to throw out. And we'll let her hit you and let you twist and fall where you think it is. And then we'll figure it out. The only way we're going to ever know that exact information is to put a live human there who's been extremely intoxicated and actually recreate it. And I mean, come on, that's the best we can do. That's the best you can do. Unless you have a live person getting hit. So if you want that exact information, Boo, you're going to be the only one that's going to sign up and volunteer to be hit by a car.
Could it cause a person to
That's right.
stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
I'm going to allow that.
Of course.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, and sneaker come off, and then stagger backwards and fall on their head?
Objection, Your Honor. Yeah, let's go.
I'm going to allow that.
Really? Really, Your Honor? How about having a broken knee from being spun around? Yeah, you're torn ACL, torn LCL, torn MCL. You're going to have some damage to your knees if you turn like that. That's what usually happens when you turn like that. I would tell him, I don't know.
Doctor?
Can you answer that?
I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults in the front yard?
Everything is supposition in this
No,
trial.
I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking.
Oh, it was conveniently not working
No,
at
there's no
night.
evidence of what he did.
True crime, Hockey Mom. It was conveniently not recording at that time. There's no, they say they have no video.
Come sidebar quickly before I start.
Okay.
And they say it wouldn't have caught that area, which I disagree with.
Sidebar.
Y'all, I got to clean my buttons.
Sidebar.
Bruh.
Oh. Well, anybody who lives in here, I'll just show it. I forget I can do that now. This is that storm front that moved through. And it's going to build up and hit me again at about 3. About 2 o'clock, it's going to blow up. That's me, that little blue dot there. I know Ronnie is somewhere near the coast, so I'm not going to tell you where she is. But, yeah, it's going to blow up again. My newest app, professional app. But it doesn't give the prediction like the other does. So there's the outlooks. I wish I was chasing. That's all I got to say. I would love to be chasing right about now. And then let me get my other app. Velocity. Oh, look at all that red. What you don't want is green and red wrapping, kind of like a yin and a yang. Because when you do that, that's when you get a lot of problems. What do we do a tilt to? Yeah, nothing major nearby right now. But isn't that cool? I can change the radars. My radar should be out of here. That's the one I want. That's San Angelo. So anyway, I'm keeping an eye on the weather for the next couple of days. We're supposed to get a lot of bad weather.
Could I have Exhibit 166, please? Did you see this photograph, sir?
I did,
He
yes.
changed it.
And do
my
you see
humble
the
opinion.
cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you
Exactly.
consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow that.
You want me to form the question?
I'm going to allow that.
You are.
So, hold on.
Sure.
Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
No, that's not the evidence. That is not the evidence.
So,
Glass, not
hold on, Mr. Jackson. Mr. Brennan.
I can
do you have a
reword
quick-
it.
Okay.
Please.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Could we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
98, please. A little more, please. Do you know what that is, sir?
It's hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
But was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
While I evaluated certainly for my report for this case, I don't know if I had known about it prior to that.
Is it mentioned anywhere in the report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay. May I approach?
Yes.
April 28th, 2025. Page 124, line 16. Okay. Yes. 124, line 16. May I approach?
Yes.
You've testified a few times on the road in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7. I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question. And if this is your answer, you should give the answer. Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
I have no further questions.
All right, Mr. Jackson?
May I approach briefly before we start?
Okay.
Y'all, remember the guy that came in and did all that recording? He wrote me a check. I don't usually do mobile deposits that much, so but I did. They put a 5 to 7 business day hold on that check. So now I got to take the check and I got to go to the bank and get it dealt with. Y'all. Which means I'm going to have to delay the Lori Vallow by about 30 minutes. It'll only take me 30 minutes or
Thank
less
you.
to do it.
Dr. Rinchler, you were just asked a couple of questions
Yeah.
about
I may do that tonight. Let's do some more
They
tasting of my whiskey, my
provided
moonshine.
information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information, and again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for
To
that.
to get through this, I'm going to let you just
you.
answer the question.
Sorry,
And-
Your Honor.
Wrenchler.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay, wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you, thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Richler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision?
I
and
called
the
them when YouTube
vehicle
wouldn't
struck me
answer. I
below
called the
my
bank.
center of mass?
I was trying to get a hold of YouTube. It just went boop, boop, boop. So I called the bank real quick. They told me how to go in.
It's going to flip you. Your center of mass will go, you'd go right up, if it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
you were shown several
Mods, put 'em
photographs,
on, Chip,
exhibits
please. Thank you.
of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not.
Mods to mod chat.
No.
Do you know
please. Mods to
how
mod chat.
those pieces of plastic got to 34 Fairview?
I do not know.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Retrial, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred, if the injuries don't match up. If you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the formal question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that, to be honest.
In your view, was there evidence of a collision with John O'Keefe?
Objection.
Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
Okay.
Doctor, you just said that you do not believe that there was a fender vault collision.
Veronica, you're going to get some rain again this evening.
Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you
We're back.
learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m., is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, can I come sidebar?
Okay.
Sidebar. Sorry about that, guys.
Sidebar.
Go to little girl's room. Sometimes we gotta go to little girl's room. Okay. A mistrial was. Oh no, I don't want rain again. Yes, you're gonna get rain again. I'll show you. Here you go, Ronnie. let it play out for you. I don't know where you are on the coast, but it looks like anywhere from possibly Corpus Christi. See, that hooks up down there. The entire Texas coast is going to get hit. Oh, it jumps. So it's going to be right about 9 to midnight is when y'all are going to get hit. So I don't know where you is, but baby girl, you're going to get hit again. True Crime Hockey Mom, will you go to Discord with that for me, please?
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
So when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a half centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the half centimeter. It's not a bruise. It's a half centimeter abrasions, about an eighth of an inch.
When you're conducting an investigation or you're doing your analysis and you
Hey,
keep
Ronnie,
saying
in
the physics
mod
and the physics,
or
do you add a
in
little bit
private
of common
message,
sense
let me
in the
know where you
equation when you're
live
considering the evidence?
so I can give you more details.
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How did it break that night?
I don't know. There's no evidence of how it broke.
I have no further questions.
All right. You're all set, Dr. Wrenchler.
Thank you, Your Honor.
Okay, guys, we've got a decision to make.
Is there an objection? So,
I'll be up late.
subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay.
Thank you, Ronnie. I know where that is.
They've been marked for identity. Jurors, I'm going to see counsel for a couple of minutes over here.
Sidebar.
Okay, guys, I've got a question for the Lori Vallow people. I got a question. Do we want to Zoom, just forget about all the other testimony and go to the live action because it's going to get good, and then go back and watch? Because y'all are all going to get the spoilers before we can catch up. So you have a choice, my dear friends. We can join live when we're done here. I gotta get to the bank, but I guess I can wait till, well, maybe I don't know what to do with the bank. I can, let me see if I can get a hold of my bank directly. Sometimes I can get a hold of them directly, sometimes you can't. But do you want to go straight into the current? Hold on. Okay, guys, that's weird. That whoever answered the phone doesn't know how to talk on a phone. Yeah, I think they're busy. Can I hold? I'm not sure. What the hell? Okay, so here's the deal. No, but what I'm saying is go into day 5 at the current time. Because there's a bomb. I mean, it you're gonna hear about it anyway. So I think what we'll do, if it's all right with y'all. Hey, how are you, babe? I'll be right back, y'all. Sorry, they're gonna call me back. So what I'm thinking is we're gonna go live with them when they go off. And then we can go back and watch the live. Today's live. There's really nothing more. I've zoomed. There's really nothing more in the Lori Daybell trial for day 4. It's really the rest of what we're watching here. Hey, we agree on something. Yes, we do. Yes, we do. Yes, we. What they do here, I'm going to do this. Let's share this for a minute. What they do is they show pictures of the car, the hallway, the Jeeps. There she is. There they are. Who is that? Lori Daybell and them taking the thing out. They show that. Then we have a break. Oh, those are better.
That is a
Now
tire that he's
both
of
carrying.
them are doing the tires.
So the previous day, we'd seen Chad Daybell rolling the tire in. Here we see Alex Cox carrying it out.
Correct.
The previous day, we had seen Lori Vallow and Chad Daybell carrying in a object of similar size to a bench seat.
Correct.
And today
We have a seat.
Exhibit 180 has previously been admitted. These are the track phone records for the 304-960-5998 munition.
So really, that's all they do. Seriously, that's it. So we're going to end that one. We're going to go into, we're going to start where day 5 is now, and then we'll go back. But we got to go into what's going on at the moment. Okay, we are on a short break. Woohoo! Okay. I didn't see anything. I just heard the bell when I looked at. No. They just opened and closed.
You done with this?
Yeah. Do you know what upsets me is they put a 5-day hold on this. So
Yeah.
I'm contacting the bank and see if they said contact your direct branch, and they may release the hold.
Okay.
All right. June, there's always common ground somewhere. Yes, there is. And we can, I really, you know what? I really appreciate some of you who challenge those who have a different opinion than you do. We can agree to disagree politely. We can banter. We can talk about it. We can share whys if we want to. But here's a safe place to do that. I welcome an opposing side. Makes life more interesting, y'all. It does. It makes it all more interesting. Ronnie, I don't know why I forgot where you lived. So we will start the new live when this one is over. I may take a 30-minute break to go and go to the bank if I have to. If I have to. Okay, good. It should ring. We'll see if it does. God, I'll be upset if it doesn't. So, yeah. Lori Daybell. She's a piece. I'm looking up her current today so we can start looking it up.
At 161, 160.
His face or what he looks like.
And so we would ask that
I'll-
FTR as well be sealed.
I'll order that his portion of the testimony be sealed on the FTR. Anything else?
Just one other thing, Your Honor, outside the presence of the jury. We previously yesterday admitted redacted affidavits. For appellate purposes, I'm just going to ask to admit Exhibit 161, 163, and 168, which are the full actual affidavits, unredacted, just for appellate purposes only.
Numbers again, 161 through 163.
Sorry, 161.
Yeah, I already have a stream
163,
set up, y'all.
168.
Y'all will be teleported if
All right,
you go if you
161,
want to be.
163, 168 are admitted for the record. They're not to go back to the jury.
Thank you.
Anything from the defense before we bring the jury in?
Yes, Your Honor. I would also like to include the letter from Tammy Lachik that she's unavailable to testify to be admitted for appellate purposes as well.
What, is it marked?
I thought I had a copy. I will get a copy to you guys.
All right, we can mark it, and once it's marked, we'll take that up.
Okay.
No, that's a different one. Okay, let's bring the jury in. I'm going to get your witness ready.
Okay.
U.S. Marshal for 9 years prior to working for the FBI.
Now,
20,
would you please introduce yourself to the jury?
yes, my name is Nicholas Balance. Last name spelled Ballance, and I'm a special agent with the Federal Bureau of Investigation.
How long have you worked with the Federal Bureau of Investigations?
Since June of 2016.
What are the different jobs you've held while working there?
So I've served as a special agent as well as a period of time as a supervisory special agent. And currently
gonna
I'm
do
assigned
it
to the
Zoom,
Salt Lake
Zoom.
City Division and work out of Boise, Idaho.
Now, prior to becoming a special agent with the FBI, did you have other law enforcement experience?
I did. I served as a deputy U.S. Marshal for 9 years prior to working
Yes,
for the
Aaron. I will
Now,
end
as,
this one and go there.
An agent with the FBI, have you been serving as a cast field asset?
Yes. So I'm a member of what's called the Cellular Analysis Survey Team, or CAST for short. And it's a specialty that utilizes cellular records as a part of investigations, trying to determine where a phone was whenever that has any significance to a criminal investigation.
How long have you been doing that?
I've been certified since October of 2019.
When you were
June-
working for the U.S. Marshals, did you do any work with
June,
cellular
put
phones there?
those
I
meme
did,
or whatever
I was
those things
assigned
are
to
in
locating
the
fugitives
GIF
for a
file,
significant
please.
period of time with my career with Marshal Service. And so I was able to use cell phone records to aid in locating fugitives successfully on several hundred occasions.
Can you tell us the education or training that you have to become a cast member?
Yeah, so for the FBI with CAST, it starts with an application process where you would express interest in getting into the program. And then there's multiple trainings that you would go through before you're considered certified. It would start with our basic course, which is a 2-day course. During that course, you're looking at cellular theory and discussing the different cellular providers that, the major ones in the United States, and looking at records and putting those records onto a map. If you complete that successfully, you would go to our advanced course. In the advanced course, it's a little bit more in depth than basic, talking about some of the same topics, but you're also provided practical tests that you have to turn in, and then those tests are graded. At the conclusion of the advanced course, if you complete that successfully, you would go on to our what's called CIRA. It's a 3-day course, or was when I went through it, and it's our critical incident readiness exercise. So as a part of that training, there's no instruction. You're just presented with problems and practical scenarios that you would have to go through, map out records, and reach a conclusion. And it's supposed to simulate like a command post style environment where you're getting information rapidly as a part of the training in a short duration. If you complete that course, you would go to our 4-week certification, and that is extensive classroom lecture that includes radio frequency professors that are teaching about in the field of radio frequency. We also get instruction from the major providers in the United States for the cellular industry, to include their engineers as well as their subpoena compliance personnel. On top of that, we have a practical exercise that's assigned to us that we have to work from beginning to end that culminates into testifying at the end and presenting a report and being challenged on that report, both by prosecution and defense that are simulated role players. At the conclusion of all of that, you would be considered certified as a member of CAST.
Do you have any annual recertification types of trainings to remain active as a CAST member?
Yes, so we have to complete a certain number of record analysis during that each year. And on top of that, we have a one-week certification conference that we attend each year that includes updates from the major providers in the cellular industry, as well as updates when it comes to the field of cellular technology from radio frequency engineers. And that's each year that you're in the program.
Okay. Have you previously testified as an expert in the area of cellular analysis?
Yes, ma'am, I have.
And as a CAST member?
Yes.
In this case, were you asked by the Gilbert Police Department to analyze some cell phone records?
I was.
Were you provided with cell phone records for a Lori Vallow for a 480, 489, 4652?
Yes, ma'am, I was.
Were you provided with cell phone records for an Alexander Cox for the phone
Thank
number 480,
you,
351,
True Crime Hockey
9120?
Yes, ma'am, I
Mom.
was.
And were you provided with track phone records for a cell phone purchased from a
Good
Walmart in
job.
Idaho Falls, Idaho, with a phone number of 304-960-5998?
For that one, I was from TrackPhone as well as from Verizon.
Okay. Were you also asked to include or analyze some Google historical location data associated with a Google account, homerjmaximus@gmail.com?
Yes, ma'am, I was.
Can you tell us what is historical location data?
Yeah, so Google offers a range of services with
Good,
their
Jim.
products, and one of those being location history. So if you were to opt into location history on your Google account, what that would do is it would, Google would maintain different locations that the device that's reporting that location information where it was historically. So if the user has that active, it would depend on the specific phone that was relaying that information to Google. So as an example, if I have a Google account and I have 3 different phones, I could access that Google account from all 3 of those phones, but if only one of them I've opted into location services, then any of the location history that Google maintained would only be associated with that specific phone for the location of where that phone was.
But the data overall from Google, they might provide information from all the devices, though, in terms of like searches that were done.
Correct. And again, it depends on how the user has their account set up with what information is going to be maintained by Google, specific to the many different products that Google has and offers to a user.
Okay. Were you asked to look at a specific time frame?
I was, specifically late September into early October in this case.
Did you create a report to help explain your process and explain the analysis of these cell phone records and these Google records?
Yes, ma'am, I did.
And because it's on a thumb drive, I'm just going to share it for you. And it's 189, if I can have my paralegal approach. Does that look like your report that you created in response to the request by Gilbert Police Department?
Yes, ma'am, it does.
State will move to admit Exhibit 189.
Any objection to 189? All right, 189 is admitted.
If I may publish. So starting on the first page of your report here, what did you include here for us to understand as part of your analysis and review of devices and phones?
So this is basically the cover sheet that I would put on all my reports, and it's showing the specific accounts that I did analysis for. So in this case, the 3 telephone numbers are listed at the top, one ending 4652, one ending 9120, and one ending 5998. Additionally, in this case, since I analyzed Google location history, the account that Google location history was associated with is listed. That's the homerjmaximus@gmail.com. The specific dates that I conducted analysis for, which in this case were September 25th, 2019 through October 3rd of 2019. The date that I completed my report, case number associated with the report with the FBI, and then my name.
Now, you were provided these records that from the Gilbert Police Department for these cell phone numbers. Did that include information like subscriber information?
It did, yes, ma'am.
So the 480, 489, 4652, when you reviewed those cell phone records from Verizon, did that show subscriber Lori Vallow?
So it did not. It was subscribed through TrackPhone. So the name was not Lori Vallow, but there was an email address on the subscriber sheet associated with her.
Okay. The 480-351-9120, was that as a Verizon record? Did you receive the Verizon or the TrackPhone records?
I did, and that was subscribed to Alex Cox.
Okay. And the 304-960-5998, was that Verizon or TrackPhone?
So it was subscribed through TrackPhone.
When we're talking about TrackPhone and Verizon, and you talked about sort of major companies, how do those all interrelate?
Yeah, so when you're looking at cellular providers, you have 2 different categories looking at kind of from a wide perspective. You have companies that have infrastructure, like cellular towers that they maintain throughout the region that they provide service to. So Verizon is one of those companies. They have cell phone towers throughout the United States. When you're talking about TrackPhone, They're a mobile virtual network operator, which basically means that they don't have cell phone towers, so they have to lease space with another network in order to provide service to their customers. So TracFone, specifically in this instance, was utilizing Verizon for the number ending 5998 to provide service to that customer.
Okay. And the Google records that you were provided for the homerjmaximus@gmail.com, did that provide subscriber information?
It did, and that was associated with Alex Cox.
The second page of your report, what is this telling us about in terms of your analysis and explanation?
Yeah, this is basically just explaining the methodology of how I created this report and the process that goes into place in order to take records from a provider like Verizon and then put those records onto a map. Again, this is the methodology of how that would be done.
The third page here, one of the things that stood out was the time. We've heard about universal time. When you are looking at most or all of these cell phone records, were you provided the times in universal time, UTC time?
Yeah, so depending on the provider or the company that's providing records, kind of the biggest difference that you'll see in the different records types is a lot of them will provide records in different time formats. So specific to Google, they provide their records in what's called UTC time. And so that's just a time standard to where if you wanted to do the conversion and see what time that was in the area where you're at, you would have to do a conversion depending on what location you were in order to get it into the local time.
So when you were mapping these cell phone records and these Google location device records, were you converting them for the purpose of your report into the local time, either Arizona or Idaho?
Yes, ma'am, that's correct.
So while we're going through your report, all of those times will reflect either Idaho or Arizona, depending on where we're looking at.
Correct, and the report will reflect those times as well.
What do we see here and what is this explaining to us?
So just to talk briefly about how cell phones work and kind of how we're utilizing the methodology that I spoke of to map and estimate where a phone was historically. One of the things that we look at is how far a cell phone tower provides coverage to. That's usually one of the major questions. So typically a cell phone tower density map is going to look very similar to a population density map. So here we're looking at the city of Phoenix, and as you can see, there's a couple of towers in downtown Phoenix and in the urban areas of Phoenix. Those towers are going to provide coverage to a much smaller area due to the number of users that are needing to access a particular carrier. As you get more to the rural areas, you can see that those towers are more spread out, and towers in rural areas are going to have a larger coverage area just because there's not as many people in those locations.
Okay. What is this page 5 reflecting?
This is just an example of what cell towers look like, not to insult anyone's intelligence, but if you look at the second tower from the left, traditionally back in the day, that's what we saw cell phone towers look like. Now there's more of a push to make them more aesthetically pleasing. So as you can see, like with the cactus, that's actually a cell phone tower, trying to disguise it so it's not looking like you have all this different metal around an area.
Page 6, what is this explanation for us in terms of what we've seen for your analysis?
Sure, so whenever I'm mapping a estimated location of where a phone was, I'm looking at a traditional tower has 3 sides. So if you look at the graphic on the left, you're looking at the tower itself, and then there's 3 sets of antenna facing 3 different directions on the tower. So if you look at the graphic on the right, that's looking from the top down. And so the cell tower is pushing out coverage kind of 360 degrees. But what providers do is they put different sets of antenna on that tower in order to optimize their network and divide that coverage up into different sectors. So whenever I'm looking at a call detail record and I'm seeing a particular call that might be of interest to an investigation, I would then look at the tower and sector that was used. So that way I can plot that tower onto a map and I can see what direction from the tower that specific sector is providing coverage to. So again, this is a traditional tower, but it's divided into 3 equal parts with sector 1, 2, and 3. And in my tower list, I'm able to see the tower that was used, and I'm able to see what's called an azimuth, which if you're not familiar with that, it's basically just showing me what the center line of a sector, what direction it is coming from the tower. So if you're looking at this particular graphic on the right, you can't see the 0, but it starts with 0 and goes all the way around to 360 degrees like a compass. So the center line of sector 1, that azimuth would be 0 degrees. Same thing with, if you look at sector 2, the azimuth on sector 2 would be 120 degrees. So that azimuth allows me to estimate the location of where a phone was in relation to where that tower is.
All right, so this information of the tower sectors and azimuth, was that included with the cell phone records that were provided to you for those 3 phone numbers?
So it's included in a different file, but all of the different cellular providers that have towers throughout the United States, they have what's called a tower list that they update pretty regularly, at least every few months or quarterly. So in conjunction with the call detail records that show me who was called, at what date and time, what tower was used, I can marry that up with the tower list, and then I can have an estimate of where that phone was whenever it had that specific interaction with the network.
So someone like Verizon will provide you with, for that specific phone number, calls made and what tower they're using, and then you're able to then get the location of that tower from Verizon to map it.
Correct. If you think about, and everybody can still do this online, but back in the day when you had your cell phone, each billing cycle, you would get that bill in the mail. It would be fairly thick because it included all the different calls that were made on that account. And so the call detail records are very similar to that. We can see the date and time. We can see that it was a voice call. We can see the direction, if it's incoming or if it's outgoing. We can see the associated number. But what you don't see on that bill is the tower information. So the call detail records that we obtain as law enforcement, they include those columns. And those columns allow me to know at a specific date and time, this tower and sector was used. And then I can marry that up with the tower list and provide that estimated location of where a phone was.
So what do we see here on page 7? We have a legend for us.
Yeah, so this is depicting how I'm going to display different pieces of information on my report. So starting at the top, you're looking at Verizon towers are going to be represented with red dots. That's going to be important because when I talked about before, where you're looking at the density of Phoenix and towers are going to provide coverage to a smaller footprint in an urban area where there's towers close by, it's important to note where other towers are in relation to the one used, because typically what we see is that a tower provides coverage to the next tower. So that's what allows me to estimate the coverage area of a tower and sector that was used for a particular interaction. Next, we see how we would represent the tower and sector. So the blue, black, and the red are going to be the 3 different phones in this case. So if you look at the blue, that's representative of a tower, and then the direction from the tower that that sector is facing. So the blue graphics are going to represent the phone number ending 4652. Black will represent 9120, and red will be representing 5998. Additionally, you see to the right the call information box. So whenever a phone has an interaction, you have that line in a call detail record, just like I talked about on the phone bill. I'm going to represent that particular call with the information that's provided from the carrier here. So you'll see the tower information at the top, the target number that it's associated with, so what record that particular line came from, what account, the date and time, direction of the call, duration of the call, type of the transaction, the word I mentioned earlier, azimuth, which gives us the direction from the tower that that specific interaction took place, and then the associated number. And then additionally to the left, you'll see a call information box where there's data interactions between a phone and a network. There's less information there, but you'll at least see the date and time and the direction from the tower that that sector faces.
Okay. So these are things we will see in the mapping that you did for this case.
Yes, ma'am, that's correct.
Oops, hold on. All right, page 8.
So I just spoke about how I would map cellular records. This is a legend to show how I would map Google location information. So I talked a little bit about Google derives their location information from different data sets. And so Google can estimate a location of a device by locating it via the GPS chip within the phone. It can do it via Wi-Fi as well as cellular. Specific to this case, we're only going to talk about locations that were derived via GPS and Wi-Fi. And so that's the icon that will be representative of that specific location line in the Google return. You also see a margin of error, which is showing Google in each specific line where they locate a device, they provide the estimated margin of error associated with that specific locate. So there will be a circle around the specific locate on the map. And then also, depending on if it's only a few locations, you'll see the information box with the specific date and time. If there are a significant number of records on the same map, it would be very difficult to read to put every single information box associated with each line. So you'll see a summary box, which is going to include the number of records that are represented, as well as the margin of error associated with each record and where it was sourced from. I'll also point out here that I know I mentioned it before, but all of the Google location history in this case is going to be reported from the device ending 9120.
All right, so the 9120 number is the phone associated to Alex Cox, or subscribed to Alex Cox.
That's correct.
So whenever we see Wi-Fi or GPS, it's from Alex Cox's cell phone.
Correct.
Now, you talked about a margin of error, and we see on page 8 here the R14. Can you tell us what that means?
Yeah, so if I were to map a latitude and longitude that Google provided onto a map, they also provide the margin of error. So I would place that icon on the map, and then I would look at the margin of error column. So it's represented by R and then a number, and that 14 there, that means 14-meter radius from that mark on the map. The radius would be 14 meters, and then draw the circle around at that 14-meter radius. That's the margin of error that they're reporting.
So does that mean if you are told that the phone is at this GPS location, and there's a margin of error of 3 meters, that the phone could be anywhere within a 3-meter diameter of the spot?
Yes, and that's how Google's reporting it, so that's how we're mapping it.
Okay, and so when we see the circle that's shaded, is that your depiction of the margin of error that was provided by TracFone or by Verizon?
So that's the margin of error provided by Google.
Google, sorry. All right. And so again, we will see those icons and those circles for the margin of error for the Google records on your mapping.
Yes, that's correct.
What do we see here in this legend?
So these were addresses that the investigative team provided to me that were of significance to this investigation. And so it's got the address associated with each one, but when I represent them on the map, it's going to be utilizing the icons to the left.
So you had Brandon Boudreaux's address, 3875 East Phelps Street in Gilbert, Arizona, as one of the places for you to have a point of interest?
Yes, ma'am, correct.
And then 2 different units at 565 Pioneer Road, apartment 175 and apartment 107?
Yes, ma'am, that's correct.
And then a self-storage plus on Airport Road in Rexburg, Idaho?
Yes, ma'am, correct.
And then a Walmart at Idaho Falls, Idaho?
Yes, ma'am.
And then also a Melanie Boudreau residence in Gilbert, Arizona.
Yes, ma'am.
So first map, can you tell us what we're seeing here and explain everything?
Yeah, so these maps are just laying out where the locations of interest were. That was provided by the investigative team. And so whenever I have like this is zoomed out a decent ways to incorporate both the address down in Idaho Falls and the addresses that are in Rexburg. And so there's a box to the side that's basically showing a zoomed in view of the apartment complex that includes the addresses for Alex Cox and Lori Vallow's apartments.
All right, so the Idaho Falls WM at the bottom is that Walmart, and then we can see the storage unit and then the zoomed out of the 2 apartments in Rexburg, Idaho.
Yes, ma'am, that's correct.
Is this just a closer up single page of that?
Yes, ma'am, it is.
All right, what do we see here on page 12?
So the previous 2 pages were up in Idaho. This is down in the area of Gilbert, Arizona. So this includes 2 addresses, one for Brandon Boudreau and one for Melanie Boudreau.
Okay. And so we see that with the bluish purple and the pinky color.
Yes, and I didn't mention before, but you can see the red dots. Those are representative of Verizon towers that are in the area as well.
Okay. So when we get to page 13, you had told us that you were provided with the homerjmaximus@gmail.com records that were obtained by law enforcement. Did those homerjmaximus@gmail.com Google records show that the records were tied to an MEID number?
Yes, so that's a mobile equipment identifier. In the case of Google, this is very similar to what's.
All right, we're back.
All right, so
And I
I had a
forgot I got a
minute to
homework
look
I
at the
gotta do.
PowerPoint. Are you in agreement on the PowerPoint?
No.
We're not. I do not want to admit it. I don't think it's substantive evidence. Objective.
Okay. Mr. Jackson?
It's exactly the substance of this. Dr. Welch's part.
Which was not objected to, right?
No, you keep saying it. Yes, there were things that were less like evidence. So yes, there were things that.
But did he object to the PowerPoint coming in?
It's been, we're all under pressure. I don't know what Mr. Leslie did or didn't do regarding PowerPoint. That's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay, a discussion, any opinions or thoughts, thought processes. These are all the tests that were completed and done, exactly as Dr. Wolf's PowerPoint was done. Dr. Wolf's PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are, most of the videos are included. Oh, no, I'm wrong. Things have been slowed down. So the videos are the same, but the videos that Dr. Ridgely used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, were slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, about which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, was there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me, okay? Whether they're in evidence or not, and which ones are not, regarding the videos.
Is the court suggesting that it's not going to let just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welchers. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have imposed that objection before it was displayed for the jury.
Well-
The jury has now seen the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They just don't like it because it hurts their case. If they didn't want to get certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing it before the jury. Given the fact that it's been displayed in, not in part, in whole, as it now sits before the jury, sits before the court for quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess, it's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay? All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Lesson needs to, I didn't mean to interrupt.
We should get you for Brennan first.
After the defendant rests, we will not be calling any witnesses, putting on any further evidence.
Okay. All right.
Your Honor, it's late in the day. We would like to review our motion for required finding of not guilty at the disclosure of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers when we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it?
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So,
The only other technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence, right?
They're correct, Mark, exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor, I mean, ruling that they're.
Are they,
I thought they were marked as identification, not evidence. If they're in evidence, they're in identification.
so I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, they're exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this court's parlance. Yes, it's YYY, ZZZ, AA, BBB.
So that means there, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
What number are we at, Madam Court Reporter?
Exhibit 230.
Okay, and we'll do A, B, C, D.
So is it Y, Z, A, and B? I think I have. I don't think I have. Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow, we need to physically put the sticker on those.
Can I just take another list while we're waiting?
Yes.
230A,
I'm sorry, say that one more time.
230A through C, 230C.
All right.
If council, there are 4,
Four of them,
A through D.
just so the record, this is limited in saying different things. They were marked for identification as triple Y, triple Z, quadruple A and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. So if you do that, I'm good, I'll get out of here.
We will do that first thing tomorrow morning.
That's fine.
Right? We will, so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
Please.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay?
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask 1 hour and a half.
Just let this pass. No, I got it, but now you can go.
I would ask for.
Yep.
I would ask.
No being report for tomorrow.
For a final summation, given the value of the case, the length of the case, the amount of evidence that's been adduced. I don't think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see about an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the
I
same?
don't have a position. I'll take whatever the defense gets.
Let me think about it.
Yes,
All right,
Your Honor.
so we will see.
Thank you.
All right, so I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you, Your
All
Honor.
right, we'll see you tomorrow morning.
All rise for the court, please.
Thank you, dear Jesus. Hold on, guys. My phone's ringing.
Goodbye.
Hold on, guys. The bank. Hey, guys, I'm on the line with the bank. I'll be right back. Okay, what do you need the number? Okay, that is going to be, I guess, 319 547 607963. I think. It's for $400. They said that they couldn't release it, that only my branch, I could go to the branch, but I work until midnight tonight. Great.
It's called an IMEI, or International Mobile Equipment Identifier. The IMEI is equivalent, kind of like a VIN on a phone. So it's associated with the hardware itself of the cell phone.
And so why is that important to see that the Google records for the Homer J. Maximus is tied to this MEID number?
So anytime, I think I mentioned it before, but anytime a phone accesses a
Yeah, but
Google
now
account,
I'm gonna
Google
go
keeps a
back.
record
I'm
of
gonna
that.
go
And one of the
majorly
things that they
negative
report is that
again.
MEID
That's
number,
bull
which,
crap.
like I said, in this case, is synonymous with the IMEI, or the hardware of a phone. So that identifies a device. So what I can do with that number is I can then take that to different cellular providers and determine whether that number has ever shown up on their network and whether they can associate that number to an actual telephone number.
And was that MEID number that we see here on page 13 that is associated
I mean,
with
it's a
Alex
good, I
Fox's
know the
Google
guy,
records,
it's a good check. It's
associated with
Security
that cell
State
phone number
Bank. I mean,
304-960-599?
I just can't get in there today
And did you
to bring it to
determine
you.
over the review of
I'm
records to see
live
when
from
that
7 in the
association
morning
occurred?
till midnight
Yeah,
today
so
and
if you go to
tomorrow.
the next page of the report, that's going to be a record that we received from Verizon. And it
Yeah,
shows that
well,
the,
yes, and
again,
this
IMEI,
is a job I did for
is
him. I've
associated with the
known him for 20 years.
304-960-5998, and they list an effective date of September
It's
27th.
a personal check. I've known him for 20 years.
And just going
He's
back
a
at the
good
bottom
guy.
of this information, we saw registration time. And a
Yeah,
first data connection. What is
353
that?
Saddle
So that's
Brook
showing when that
Drive,
device
well,
accessed
Harper,
the Google
Texas.
account for the first time. And we see also the September
I mean, this is
26th,
not a fraud. I know the
2019 at
person.
7:58,
He's
which
written
would
me
be
checks
in a UTC
before on
time. So
another
to get to
account
either
that I
Idaho
had.
or Arizona, you
I
would have
don't
to
have it
subtract 6 to
anymore.
7 hours to get to the time of where that occurred.
So to be clear that we understand, what we're seeing now is that the Homer J. Maximus at gmail.com records from Google, the Wi-Fi and the GPS data are always.
Why
being
was
attached
I
to
not
the 304.1
muted?
number, correct?
Why?
But there is data in the Google.
I don't care if y'all know. Give me a good check. And the bank is calling it fraud. Possible fraud. Because this guy has never given me a check on this account. I just think it's bullshit. Oh well. I don't have time for that
now
anymore.
has been associated to that 304-960-599.
Okay, what I'm going to
Yes,
do
and as
is
I
we're
mentioned-
going to stop here, guys. What I'm going to do. Sorry, guys, that's life. I pushed the mute button. It was red on my end. It was not red on your end. Oh, well, such is life. Anyway, so what I'm going to do is give me a second. I'm going to go live on the other. I'm going to let you guys watch this for a minute. I'm going to go live on the other, and then I'll end you and we'll teleport. Okay. We'll teleport. All right. I'm going to play this a little more.
Mentioned earlier, you can have multiple phones that access your Google account, but unless you have location history turned on every single one of those phones, Google is not going to record the location history associated with those phones. It's only going to record it on the device that you specifically turn that location history on.
So when we get to page 15 here, what are we seeing in these records?
So whenever you have a phone that is, like in this instance, purchased through TrackPhone, but utilizing the Verizon network, there's two different places that law enforcement has to go to get the complete set of records. So we would have to go to Verizon in order to see the call detail records and what towers are being utilized by that phone. But the point of purchase and subscriber information, we would need to go to TrackPhone. So specifically, this is the point of purchase information from TrackPhone associated with the number ending 5958.
So this tells us that this 5958 track phone was purchased at a Walmart at Idaho Falls, Idaho.
Yes, correct.
And when does it show that being purchased?
So it shows it being purchased on September the 25th, 2019 at approximately 7:10 p.m.
Okay. And does it show a store number of 5494?
Yes, ma'am, it does.
And
so when we get to page 16, we start to see those icons for the Wi-Fi. So we're now talking about the 9120 number.
Yes. And so being this is the first map, I'll explain.
Okay, guys, the other live is up and running. Yes, you know my business. I got a check for the job for that guy. And well, because that bank hasn't had that person and check written to me in my bank account over there, they're putting a 5-day business hold up to 7-day business hold, and I'm trying to get them to release it. And I don't want to go negative in my account. Baby girl got some bills to pay. I got to pay the internet to keep this up and going. Y'all, you know how it is. It's life. And you know what? I'm human. This YouTube channel is like being in my home. There may be a call come in that you get to hear. Oh, look, I love each and every one of you. Y'all are so freaking amazing. We have gone over 500 videos. I forgot to celebrate it. We'll celebrate it another day. And we are going now over to the Lori Day Bill because guess what? Drama is getting thick and deep in there, guys. We got a good night ahead of us. So come over. It should teleport. If it doesn't, just hop on over to the new live. See you 10 o'clock, 9 o'clock in the morning, Central Standard Time. I get an hour more sleep. Thank you, Jesus. Okay. See you over there. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.